in union law. Michelle, welcome, and we're looking forward.
Thank you very much. My topic today is free speech, defamation and the Constitution, and forgive me if I speak a little bit quickly, but we're obviously pressed for time. This is a pretty broad topic, so there are a few issues in particular that I'll be focusing on in this paper. I'll firstly talk about the role of Parliament as a protector of free speech, but they haven't always acted as a protector of free speech. We see lots of examples where they've threatened free speech, and I'll be talking about some of those examples. We can see a couple or quite a few, in the implied freedom of political communication cases. And I also want to pause in the presentation and make some comments about the media. And I want to talk about a few implied freedom of political communication cases involving the media, where the media have been sued for defamation. So I'll make some comment about the adequacy of the implied freedom in that context, and perhaps whether we need better reforms at a basic level to remind Parliament about its role as protector of speech, but perhaps also to protect the media as well if they're sued for things like defamation. Now, firstly, I'll say something that we probably all know, which is state and federal parliaments can make laws that restrict free speech. We don't have an express guarantee in our constitution, such as in other jurisdictions, such as the US and Canada, but we do have something that the High Court has implied, which I'll talk about today, so the implied freedom of political communication. Now, that was a deliberate decision of the framers of the Constitution. There was quite a lot of debate, particularly at the 1898 Melbourne session of the Constitutional Conventions about that. And the framers decided that the common law and our system of democracy should be sufficient to protect rights. And I think it was Justice Dawson who said in ACTV and the Commonwealth that the theory was that Parliament would limit rights such as speech at its peril. So people wouldn't like it and they'd vote Parliament out. Okay, so we can see some examples though of how Parliament hasn't always acted as a protector of free speech when we look at the implied freedom of political communication cases. And I'll just pause for a moment to just briefly note what the implied freedom involves. And then I'll talk about a couple of case examples where Parliament has threatened free speech. So what's the implied freedom of political communication? It's not an absolute personal right that you or I have. It's a limitation on the legislative power of state and federal parliaments when they're enacting legislation. We'll see that there's a balance there as well. So they can make laws, as I've said, that restrict free speech, but they can't go too far, according to the freedom. It's a freedom to talk about all aspects of politics and government and governmental institutions at all levels of government. So, local government, state government, federal level of government. It's a freedom to criticise our elected representatives and people who seek to become our elected representatives. And it's also freedom to criticise and talk about and discuss other types of political figures, like trade union leaders, for example, controversial political commentators like Alan Jones and so on. Where does it come from? It was implied by the High Court into the Constitution in two cases handed down on the same day in 1992, and those cases were Nationwide News and Wills and Australian Capital Television and the Commonwealth. So in those cases, the High Court said that we have express sections in the Constitution that establish our system of representative and responsible government, and it's necessary that we have this freedom to talk about political and governmental matters in order for our democracy to function properly and in order for us to make informed decisions at the ballot box. So I just want to say a few comments about what happened in these two cases, because they are good examples of how Parliament has actually legislated to threaten free speech. So the first one is Nationwide News and Wills. Now, in that case, the Australian newspaper published an article called Advance Australia Fascist, and it was very, very critical of the Australian Industrial Relations Commission. Now, the federal government had amended the Industrial Relations Act, the Commonwealth Act, to make it an offence punishable by up to 6 months imprisonment to basically criticise the Industrial Relations Commission. So the newspaper were prosecuted under that provision for publishing this article. Now, in its defence, the newspaper argued that they had published the material pursuant to an implied freedom to talk about political and governmental matters. And a majority of the High Court agreed with that and found that provision of the Industrial Relations Act to be invalid. So the High Court said that making any criticism whatsoever about the Industrial Relations Commission, an offence, went way too far. Now, the second example that we can see there of where Parliament has threatened free speech is Australian Capital Television and the Commonwealth. Now, in this case, the Commonwealth Parliament amended the Broadcasting Act to greatly restrict or prohibit, in some circumstances, political advertising. And Australian Capital Television was a television broadcaster, and they, with other broadcasters, challenged this legislation. What the legislation did was that it provided that once an election was called in a state or territory, and that would include a referendum, there would be a complete ban on political advertising, with the exception of something called free time. And the legislation required that broadcasters had to give advertising for free to political parties. But the problem was that 90% of free time was to be given to political parties already represented in Parliament in proportion to their level of representation. So it was quite self-serving. Allegedly, there was a legitimate purpose behind this legislation, which was to prohibit corruption in the political process. So the idea was that political parties might be put under pressure by donors of large amounts of money towards their political campaigns. Now, a majority of the High Court found that that amendment was invalid. So they did a balancing act in coming to that conclusion. So they weighed corruption in the political process versus freedom of political speech. And they found that the Commonwealth Parliament had basically gone too far. The restriction was too extreme. Now, I've said that there's a kind of balancing that the High Court does. And this is the tests for what the High Court will consider when they're considering whether legislation contravenes the freedom have been qualified in those subsequent cases, so Longy and Coleman and Power. Essentially what the High Court looks at is two things. First, they ask a basic question. So, does the legislation in any way restrict freedom of political speech? So even things like defamation legislation could do that. So the answer would be, well, yes, it does, because you can't just say whatever you want. So it's a very broad question. But then it's qualified by the second question. So it looks at whether there's a legitimate purpose behind the legislation and whether Parliament has acted proportionately or appropriately in achieving that purpose. So even if the legislation does restrict speech, if Parliament's acted reasonably, the legislation will nevertheless be valid. So there is a kind of balancing going on there. I just want to pause there for a moment to just flag, perhaps something that we can watch out for, a possible future threat to speech, which would occur if the recommendations from the Finkelstein report on media reform were implemented. Now that report's been very criticised, and I won't talk about it very much because it's the subject of Professor Fernandez's presentation next. But that report recommended very broad-reaching reforms to the media. So it recommended the establishment of a sort of all-seeing, all-knowing news media council with coercive powers. So that could potentially be a threat if Parliament seeks to implement that. I just want to now come back to the adequacy of the implied freedom of political communication. And I want to have a look at this theme of the media and have a look at some cases that are known as the defamation cases. And in those cases, the media have been sued for defamation and they've pleaded the implied freedom as a defence to a defamation claim, which has been very controversial in and of itself, but that's probably another conference paper for another day. Because I'm talking about defamation, what are we talking about with defamation? We're talking about, basically saying bad things about someone that would have the effect of harming their reputation to the public at large. So it's the effect of the defamation, the harm that results, that's relevant, not the intention of the statement maker. I'll just have a look at some of these cases because we can see if we're thinking and talking about the media, the implied freedom has had somewhat limited success for the media. So that perhaps suggests that we need some more protections for the media in terms of freedom of speech and freedom of the press. In Theophanous, a newspaper was sued by a federal member of parliament, Dr. Andrew Theophanous. They had published comments that were very, very critical about his views on immigration. And in its defence, the newspaper pleaded that the statements were published pursuant to an implied freedom to talk about political and governmental matters. And a majority of the High Court recognised that the implied freedom could be used as a defence to such a defamation claim. So that was somewhat good news for the media. Stevens is another similar case involving the Western Australian Parliament. The West Australian newspaper published 3 articles that were very, very critical of a Western Australian parliamentary committee. The committee said that they were going on a 22-day interstate and overseas study trip, but the newspaper said that it was a junket and a waste of taxpayers' money. And so the newspaper were sued by the committee members for making those comments. And the same majority of the High Court found that the freedom, again, could constitute a valid defence for a defamation claim of this kind. The next case involving the media and defamation is Longy. Now, in this case, former New Zealand Prime Minister David Longy brought defamation proceedings under the New South Wales Defamation Act against the ABC. It was concerning a broadcast on their Four Corners program and had made very critical comments about him. The ABC tried to argue in its defence that the Defamation Act was invalid because it contravened the implied freedom to talk about political and governmental matters. They were actually unsuccessful there. And that was because when the court did that balancing act, they found that, yes, defamation legislation does restrict speech, but on the other hand, it is reasonable because it provides lots of reasonable defences that the media, for example, could use in these circumstances. Another case that's not a defamation case, but I thought that you might be interested to hear about it, is the case of Hogan and Hinch. So this is quite a recent decision in 2011 you may have heard about in the news. In this case, Hinch, or Darren Hinch, as in, shame, 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 Darren Hinch, was charged with contravening Section 42 of the Serious Sex Offenders Monitoring Act, a Victorian piece of legislation. He was charged with 5 counts of contravening a suppression order. What he had done was he had named, because Hinch liked to name and shame, probably still does, he named and shamed a registered sex offender on his website, and he also named a sex offender at a public rally, and obviously those people's names had been suppressed by the suppression order. So Hinch challenged that legislation unsuccessfully. And Chief Justice French, in his judgment, said, well, yes, the Act does burden political free speech, but it is for a legitimate purpose, which was, protecting the community and the rehabilitation of sex offenders. So that was found to sort of justify the infringement of freedom of speech. And a lot of us would disagree with that reasoning, but the other majority justices agreed with that reasoning too. You might be thinking, what about Andrew Bolt? Is this the sort of thing that he did argue? He probably should have. I don't know whether he would have been successful though. So this wasn't a defamation case. This was brought under the Racial Discrimination Act, and Andrew Bolt actually pleaded one of the defences available under the Racial Discrimination Act. That was in section 18D. So he was alleging that he made those statements about Aboriginal people in good faith, and that it was in the public interest and it was fair comment. So he didn't actually plead the implied freedom. He used that defence instead, unsuccessfully, of course. Okay, I just made friends with James Allen, I think, yesterday. He might not be my friend anymore after this, but I just wanted to consider some... It'll be over soon, I promise. I just wanted to pause to look at some reforms, just going back to Parliament at a more general level here, to remind Parliament about this responsibility that the framers intended it to have as a protector of rights such as speech. So should we consider something like a legislative Bill of Rights? We have one in the ACT and Victoria. There is one currently, I would say probably languishing in the federal parliament, who have had better things to do with carbon taxes and debates about sexist language and that kind of thing lately. But it is sort of, I think, stuck in the Senate at the moment. There has been a Senate report recommending some reforms there. So how does a legislative Bill of Rights work? It does actually serve as a reminder to Parliament during the legislative process. So the way that they tend to work is that when a parliamentarian wants to introduce a bill into Parliament, they have to put forward a compatibility statement saying whether the bill is consistent with rights, so it could be consistent with freedom of speech, and if not, why not? And also the bills will be subject to scrutiny by a parliamentary committee. So it could just be a little bit more of a reminder to Parliament when they're enacting legislation about, what might be the impact, for example, on speech here. Some more points for further consideration. With the media, going back to the media, we've actually got quite a good Defamation Act which seeks to sort of clarify and codify some of the common law of defamation, and it does contain some quite good defences that the media could use, so and truth and so on, qualified privilege. But perhaps it should mention the media and the importance of the media in our democratic system of government and promoting political debate a little bit more specifically. So perhaps there could be some reforms there in order to protect the media, and perhaps there would be more benefits such as open media from that. So perhaps in some of the defences, perhaps something that could be taken into account, is that it was the media disseminating this information. So controversial, but I'm just raising the question. There could also be some benefits about, clarifying the limits of the implied freedom, because, obviously this is unelected judges that we're talking about coming up with this freedom, and that's one of the reasons why, I don't like a constitutional Bill of Rights as well, because, rights, they sound very sexy and everything, but there's lots of problems, I think, with absolute guarantee of rights. But perhaps, there's some opportunity here as well for clarifying the implied freedom of political communication, and perhaps even clarifying whether it could extend to something that Dr. Zimmerman was talking about in terms of, does it now extend to religious speech, which is, very much connected to politics these days as well. So thank you very much.